140 words per minute for 8 minutes. 5 seconds more. Start. The petitioner, via the present writ petition, has assailed the impugned award dated 8 October 2015 of the Labour Court in a claim filed by the claimant, that is, respondent, herein challenging the termination of his services with a prayer for reinstatement, continuity in service, full back wages, and all consequential benefits and litigation expenses on the ground that the petitioner herein had illegally terminated his services, whereby the impugned award, the claim of the respondent herein to the present writ petition had been partially allowed, and the respondent herein had been held entitled to the reinstatement in service with continuity in service and all consequential benefits, and also held entitled to 50% back wages from the date of the termination of his services. While order dated 16th February 2016, the operation of the impugned award had been stayed. The parties to the writ petition were also referred to the Lok Adalat for an amicable settlement, which, however, as per the report of the members of the Lok Adalat, could not be resolved as none put in appearance on behalf of the management. When the matter was taken up for hearing again, it was submitted on behalf of the respondent that the respondent had since superannuated and that his son has expired, and he sought an expeditious hearing, and that the relief of the reinstatement in service had already become infructuous. The prayer was thus confined to the 50% back wages from the date of the termination till the date of the superannuation. In view of the submissions made on behalf of either side and the undisputed facts on the record, it was considered appropriate to hear the parties on the merits of the writ petition. The respondent joined the services of the petitioner as a driver for heavy motor vehicle services and had been in service with the petitioner for more than 25 years, but that his HMB driving license expired on 1st January 2007 and was not renewed for the reasons that the respondent herein was involved in a fatal accident case and was facing trial. The respondent herein is stated to have attained the age of 55 years in March 2011. In terms of an order, the drivers of the petitioner could get the benefit of the enhanced retirement age subject to their being found fit in every respect after a thorough medical examination by the medical officer, but if they were found unfit by such medical examination, they were to be retired from the services of the undertaking without any notice. While a show cause notice issued by the petitioner to the respondent, he was informed that his HMB driving license had been cancelled by the Transport Corporation due to the fatal accident, and as he had been working on the basis of LMV, he was called upon to present the renewed HMB license within a week, or else the petitioner stated that it would not be possible to continue the services of the respondent herein, and that further action according to rules would be taken against him. A further show cause notice was once again issued to the respondent to present his HMB driving license, and if the same was not produced, it would not be possible for the petitioner to continue with the services of the respondent. The respondent failed to produce any HMB driving license before the competent authority of the petitioner. A third show cause notice was issued to the respondent, and once again he was called upon to produce his HMB driving license within a week. The respondent, via his letter before the Labour Court, admitted that his HMB driving license had expired on 30th January 2007 and stated that he was facing trial in an FIR and that he had applied for renewal of his HMB license, but the concerned department till then had not renewed his license. It was thus submitted by the petitioner that the respondent, having failed to produce his HMB driving license, the petitioner was left with no option but to compulsorily retire the petitioner. While letter dated 30th January 2013, the respondent herein stood retired from the services of the petitioner corporation. The respondent herein challenged the compulsory retirement order before the Assistant Labour Commissioner, and conciliation proceedings were taken up which were not fruitful, and thus the conciliation officer issued certificate to approach the Labour Court for adjudication of the industrial dispute, pursuant to which the respondent filed his statement of claim dated 21st March 2014 before the Labour Court against the petitioner, seeking withdrawal of his retirement and sought relief of his reinstatement. An opportunity was granted to either side by the Labour Court to lead evidence, and after arguments were addressed, the Labour Court held that the respondent was entitled to the reinstatement in service with continuity in service and all consequential benefits, and also held him entitled to 50% back wages from the date of the termination of his services. Whereas on behalf of the petitioner, it was urged that the impugned award of the Labour Court be set aside, and on behalf of the respondent, it was urged that the order of reinstatement in service with continuity in service and all consequential benefits and 50% back wages from the date of the termination of his services be upheld and be directed to be implemented, as it was submitted that the services of the respondent had been illegally terminated. On a consideration of the available record and submissions made by either side and the impugned award of the Labour Court, and taking into account the factum of the services of the respondent and that his license had admittedly expired on 31st July 2007 and was not renewed by the Transport Authority, as the respondent facing trial in a fatal accident case, and the Transport Authority had reservation to renewal of the driving license, and taking into account the factum that the petitioner gave ample opportunity to the respondent via show cause notices, and also the factum that the petitioner earlier via memo stated that the employment of a driver in such a case could not be utilized any further beyond the age of 55 years merely because the respondent during the period continued to work despite his having attained the age of 55 years in March 2011 itself, cannot be granted any benefit for continuing in service beyond the age of 55 years in terms of the office order. In these circumstances, it is held that there was no illegality in the termination of the services of the respondent, whereby the respondent stood retired from the services of the petitioner's corporation with effect from 31st January 2013 in accordance with extant rules. In view thereof, the impugned award of the Labour Court directing the respondent for his reinstatement in service with continuity in service and all consequential benefits, which has since become infructuous, and the entitlement of the respondent to 50% back wages from the date of the termination of his services is thus set aside. However, as was submitted during the course of the arguments addressed on behalf of the petitioner, the respondent would be entitled to all the retirement benefits due to him from the date of his retirement, that is 31st March 2013. The petition is disposed of accordingly.